Okay, hi, and thanks for joining the Talking Animals Law and Philosophy series. This is the second event in Easter term. My name is Raphael Fazel, and I am the co-director of the Cambridge Centre for Animal Rights Law. I'm going to say a few words about how the event today will work. We will start with a presentation by our speaker. That will take somewhere between 30 and 45 minutes. And we will then segue to a Q&A and discussion part. The event will end at 6:30 p.m. UK time, but I appreciate you might be in different time zones. So we're looking at maybe 1.5 hours or so. Some of you may have noticed that we have changed the format of the series slightly. So we're now in Zoom webinar, which means that we have a greater sort of spotlight on our speaker, and attendees don't see one another. And the way in which you can come in the discussion is by using the Q&A box on the bottom of your Zoom app. So just click on Q&A. You can type in your questions and your comments there. You can see what other people are writing, and you can upvote and comment on other questions, and then we can take those in the discussion once we get there. Okay, we are recording this event, so if you want to watch the talk later or recommend it to a friend, it will be uploaded to our website and YouTube channel in due course. So it is now my great pleasure to introduce our wonderful speaker today, and that's Małgorzata Lubelska Sazano. She's an assistant professor at the University of Silesia in Poland, and perhaps most notably, she's visiting fellow at our center at the moment, and we're really pleased to have her at least for another couple of days before she heads back to Poland. Małgorzata obtained her PhD degree in 2018 after having defended her thesis on the problem of animals as objects of obligations at the universities of Silesia and Osnabrück in Germany. In 2018, she also obtained an LLM degree from the University of California, Davis. Since then, she's published extensively in the fields of animal law and animal ethics, and she's received numerous awards, including a Max Planck Institute Fellowship, a DAAD Fellowship from Germany, and the Polish Science Foundation Award for the best 100 young Polish scientists. We're really pleased to have her here today with her presentation on the research that she's been conducting during her time here in Cambridge. Małgorzata, over to you.
Hello, everyone. Thank you, Raphael. It was such a wonderful introduction. I couldn't make it better. And it is really a pleasure to be here today and to be able to talk about animal rights. I also want to be actually at the end of my fellowship at the Cambridge Centre for Animal Rights Law. And I really want to thank Sean and Raphael for this opportunity and their constant support. Thank you very much. So moving to the lecture that I have prepared for today, I wanted to focus on the fact that in the past, I have been undertaking my research in Austria, Germany, Poland, also in USA, and obviously now also in United Kingdom. But I have always focused on private comparative law and the EU law. So when my research interest moved towards animal rights, I realized few things about the EU law and this is what I want to talk about today. But first, I will present shortly a roadmap. So first, I will focus on the issue of the European culture and how does this connect with the European model of animal guardianship. Within this topic, I will also try to very briefly present you what constitutes the European animal law, how does this impact animal rights, and secondly, I will move to the issue which combines ethics of care and vulnerabilities in the EU law. Thirdly, I will move to the main topic of my presentation, which is the guardianship for animals itself. And at the end, I will make conclusions. So, first of all, I believe that the European culture and law, which is a part of it, is different from other legal cultures, therefore calls for different means. European foundations of animal law are so different than the so common or maybe of common interest lately, the rights of nature approach, but also from the attitude to animals represented by the followers of Buddhism and Hinduism. In this aspect, I will focus on what is so different in the European culture. But secondly, I also want to state at the beginning, before moving to the details, that I believe that what the humanity has been doing until today and what brought us to the Anthropocene era does not work anymore for us, for the animals, and for the planet. The expensive and aggressive attitude towards the planet, globalization, previously also colonization, did not serve humanity, did not serve the planet nor the animals. Therefore, I believe that it is time to take direction more towards empathy. And this is where we meet the ethics of care. Also, when working on my book, it became evident to me that the European legal culture shares something which is a very salient characteristic of this European legal culture. It is a commitment to the welfare of the vulnerable one, or maybe better, the weaker one, the weaker party, but not always in the meaning of the contract law. It is a party, it is also simply the vulnerable one. This can be linked to the ethics of care and also the vulnerability theory, a subject that I focus on in the book I am currently working on. So we have these two aspects. The fact that the Europeans have a different culture, which requires a different cultural approach to animal rights, and the fact that this European legal culture does care for the vulnerabilities. And this constitutes the core of my ideas, combining these two issues. Basically, I can see the EU law as a living manifestation of the ethics of care in many aspects. Therefore, the general legal principles that would enable granting a broader scope of rights to animals are already there in the EU legal principles. So when we take this into account, changing the ownership of animals to guardianship would actually be in line with the current EU legal principles, and the scope of rights granted to animals would change in result, also in result of the interpretation of these rights. So now I will move in details to the first aspect, which is the European culture. Let's consider what constitutes this European culture. I think it's important to understand that the way we treat animals today is mostly based in our Christian roots. Treating animals as beasts which are so different from humans, and the humans have sway over animals, does actually come from the Bible. Religion and law have always constituted an important part of a culture, and so Christianity has also built our European culture. And this was the reason to make this culture different from other ones, and also to create a different attitude to animals from the one that can be observed on other continents. Already Peter Singer in his previous books underlined the influence of Christianity for over 2000 years. The problem with animal rights in Europe is based on the culture, and that God gave us humans dominion over them. And what is mostly important, only we humans have immortal souls. The effect on how Europeans think about animals and its connection with Christianity are actually bigger than one may think. It has influenced our history, our culture, our relationship with animals. And I think it is important to understand why people think, or rather feel from generation to generation, why is it okay to exploit animals? This is basically what our Western culture is based on. And this has been spread through imperialism, colonialism, and Christianization. But it is not how it has always been. So when looking at how Europeans feel about animals in the world, it is important to understand two things. Firstly, the idea that humans have dominion over animals is rooted in the history of Christianity and its broad influence in Europe. But secondly, people used to think that animals had special abilities and they were different from humans, but they didn't think that they were better, that the humans were better than non-human animals. This has been stated in the works of many ancient Greek philosophers like Plato, Aristotle, Plutarch. Their views have expressed that they believed that animals also had immortal souls like humans, but I guess this is not the main subject of our lecture, the history, and this is just a little part of it, which I found very important to know why everybody in Europe has the same attitude and where does it really come from. So it is important to know that whereas the Christianity has impacted our views on the legal position of animals and on the approach that humans have to animals, but before Christianity, the philosophy which was rooted here in Europe said something completely different. And these are also our roots, which maybe we should consider going back to. However, we also have different common things in Europe. And another common issue when it comes to animal rights is the deification process, which probably everybody knows about. And I also don't want to waste too much time talking about it. But it's important to know that it started in Europe. It started in the 19th century. And it was the time when more and more people started to believe that the idea of treating animals as though they were just things was wrong. And the reason was that the scientists were discovering more facts about the world, about the animal sentience, and the common knowledge of the society was also becoming more advanced, obviously. This led to the deification, which until today is being referred to as the pinnacle of the 20th century developments of animal law. And it does also cause many problems because this is what led us to the welfarist regime in Europe, basically, by putting animals in a position when they are not things, not persons, they are something in between. But about the thinghood and personhood on this, what animals are in between, there have already been many talks. I have also seen, and I recommend those who are interested, the talk of Angela Fernandez and quasi-personhood of animals. However, this is what started in Europe, what started with the deification process, and this is also our view on animals, the view that everything has to be either persons or things come from the Roman law. And this is also our tradition. So it is important to mention it. I believe that this is very different from the legal standing and other legal views that are connected with animal rights that we don't have in Europe. All our position relies on the idea that animals are not things, but are basically treated as things. And we cannot diminish that this is where we should start from. Now I will move to the second part, which is maybe more important. Less has been talked about it, and for sure it gives also more hope for the future. At least I can see the hope in there, and this is already positive for me. There is an idea that the EU legal framework is not only based on our common history, but also that we share common principles. And these principles are made to protect those who need protection, who need this protection because they are a weaker party or vulnerable person. And this is a view that is basically rooted in the ethics of care tradition. This is especially important for the citizens of European countries of the so-called old continent, many of whom suffered greatly during the Second World War, for the people whose ancestors survived the trauma of concentration camps. So it is evident that the European history is characterized by hatred, intolerance, and also, unfortunately, the sense of superiority over other beings. We have already been there at this point. But in light of these historical lessons, I believe it became an imperative for the Europeans to act responsibly to avoid any self-destruction in any means in the near future. But what is important, more and more people realize that countries can not only be destroyed by wars, but also other problems like hunger, climate change, pollution. And one of the manifestations of this sense of responsibility for others and for the planet as a whole is by trying to make Europe the first climate neutral continent by 2050. We as Europeans want to show other countries and continents what we are doing so that they may want to do the same and that European member countries can achieve higher objectives, even if this results in inconvenience, let's say, for various stakeholders. This can be done by using legal mechanisms that are more or less flexible and recognize also the individuality of each member country. This is, for example, the aim of EU directives. There are obviously also regulations, which are less flexible ones, not flexible at all, actually. So coming back to the fact that the common characteristic for the European legal culture is the commitment to the welfare of the weaker one, this idea is connected with the ethics of care and vulnerability theory, something that I focus on in my book. I believe that the manifestations of the ethics of care in the EU law are visible in various places. In the public law provisions, like regulation of a compulsory system of social insurance, like pensions, general healthcare availability. However, the main characteristic of the private law systems of the European Union member countries is also designed to protect the weaker party. So, the connection between the European system of civil law and feminist ideas about care and vulnerability is clear, can already be observed as existent in the EU law through various legal mechanisms. Firstly, the issue is evident in the regulations providing legal guardianship. These institutions encompass not only children, but also older individuals, those with mental disabilities, and those who are absent. In some countries, there is not only representation possible for those who cannot speak for themselves, but also for people whose existence is not even known, like the owners of historical buildings from the 20th century who were lost during the Second World War, whose ancestors are not known to the public. But what is most important is in the idea of guardianship, from my point of view, is the aspect of being someone's guardian, which is connected with the duty to act in someone's interest. This constitutes the clue of guardianship. Abusing the guardianship relationship for own reasons, this is failing as a guardian. So that's why this is so important. The guardianship focuses on the interest of the weaker one, of those who is in need. And for those who are not aware where it comes from, the ethics of care focuses on paying close attention to the feelings of all parties involved in a moral dilemma, and the aim is to achieve a satisfactory outcome for everyone involved. This idea comes from Carol Gilligan's work In a Different Voice, where she challenged male-centric models of moral development, and instead of this, she focused on relationships and care. Her research, conducted as a response to the thesis of her colleague Jonathan Kohlberg, Jonathan Kohlberg suggested that the application of moral theories present certain challenges for women. But Gilligan showed that basically this is not a challenge for women, but it's just the idea that women approach morality in a different way, in a consultative way. So Gilligan proposed that as women's sense of morality evolves alongside their sense of self, they tend to prioritize the ethics of care instead of the tendency to prioritize ethics of justice, which is more typical for men. So over the past decades, the ethics of care has evolved from its traditional focus, as it was at the very beginning, on personal relationships, where care was fundamental to family life. Now, this ethics of care approach has spread to many different areas, from medicine and society to law, politics, international relations, and as I have already said, to many aspects of EU legal framework. The ethics of care approach is also based on the idea that all beings have an equal value, no matter what species they are. It also recognizes that people and non-human animals can have different abilities. This approach is all about treating all beings fairly and with respect, because each of them has unique qualities and different contributions. So, consequently, the ethics of care is visible also in the credibility of legal capacity in the EU member states' legal systems, and also different regulations referring to this issue in the EU legal framework as a whole. This constitutes the main argument for the theory of legal guardianship for animals, proving that the scope of rights and the way as the guardianship in reference to animals is being structured can differ depending on different circumstances, as it is in other aspects of EU law. And there shall be no risk that various conservative circles would find it inappropriate, since there are already so many different approaches and institutions which involve the institution of guardianship. Also, the protection of the weaker party principle in the contract law, which prevails over the previously being the most important principle, the private law autonomy. It constitutes another example of this phenomenon. that the ethics of care is gaining importance in the EU law. It is most visible in the consumer protection. This is an area where the EU has become especially well known. Now let's move to the guardianship for animals. So the most important part, I was trying to say the background as briefly as possible, but I'm not good at saying things briefly. So we have different approaches in the animal rights law theory to grant fundamental rights to animals. We know the so like us approach, interest-based approach, the rights-based approach, capabilities approach. But all of them, in my point of view, have one thing in common. Animals have to stop being considered as things. And obviously, the deification in European countries does not fulfill this role in any way. In my opinion, animals do not have to be called persons to have things. I don't believe that we have to stick in this Gaius division into things and persons. The most important issue for animals is not to have the same status as things. So if majority of the society cannot imagine making animals persons, they can remain a different category, animals. Saskia Stucki or Angela Fernandez share the same approach, referring to it as one of many possible options for animals. But guardianship is the key to make animals parts of our society, whatever idea we base on. In the work Zoopolis, Sue Donaldson and Will Kimlicka found the idea of citizenship being the most suitable to grant animals access to their rights. And I believe it is a brilliant idea, but it is much more complicated. What I base on is the simplicity. I believe that simply changing the ownership for guardianship, which is at least at the first glance an idea that is so simple that it is almost not possible that it is still not existent as an approach that is more popular. So the most important things is the fact that humans, instead of exploiting animals, shall become their guardians. It seems so difficult to be achieved, but I don't believe it is. If we simply change ownership for guardianship and animals become a different category, not persons, not things, but something what they already are, animals, not much will change from the outside. It is rather acknowledging the state of facts. But what changes is the point of reference. So once animals are not owned, but guarded, and once they are not something between persons and things, but they are what they are, animals, sentient beings, their rights and freedoms will be interpreted accordingly. So coming back to the Europe and the European model, different legal scholars, like I guess the most popular view of David Favre is that he proposed a reasonable draft of a guardianship model, but it wasn't based on the European law and culture. The idea of trust is also not known in the civil law tradition. This is not only the common roots in the Roman law tradition, which affected the European legal thought throughout the centuries, also the fall of the Roman Empire, the history of the Code Napoleon that we share as European countries, the influence of Christianity that we have in common. It is clear that many people in Europe share the same values and views, have worked together in many areas for a long time. Over the last 75 years, countries within the EU have obviously adopted a significant set of common values. And these values consist in Europe of taking care for the weaker ones and already existent in the EU legal framework. And I believe that this is enough to proceed a change basing on this what is already existent in the European Union. People get used to higher standards quickly, it is said. But if you ask public opinion at the time when slavery was outlawed, when the hitting of children was outlawed, and when women were giving the vote, those issues were just as controversial as our animal rights debate is today. And just like the previous ones, this debate is about the abuse of power and the exploitation of the weak. However, in this context, there is hope because this is exactly what the EU law protects in all its framework. So it's important to prove the manifestations of the ethics of care are already existent in the EU law and base on something what is already existent. So moving slowly to an end and to the conclusions, I believe that at least all vertebrates shall have granted a life worth living, a positive life that enables them to flourish. And how can we structure the scope of these rights? We all know, probably, we all know the so-called 5 freedoms. 5 freedoms means that animals shall be free from hunger, pain, fear, discomfort, and free to express normal behavior. They are proudly claimed to be the foundations of the current EU animal welfare system, but they are currently not even close to being covered by the legal provisions in the legal systems of the EU member states, nor by the EU law itself to the extent as I understand, and I assume that most of the people listening to me today understand that they should be understood. However, as I mentioned before, I propose a model that is based on simplicity, and in its scope, it encompasses the animals that are already covered by the EU member states' internal legal systems. And it refers to the ideas which are already existent in the EU legislation. The crux is that by granting legal personhood to animals, the dimension in which humans understand 5 freedoms has to change and will change because we change the object, so we change the interpretation. If we change the object, the animals, that they are not something like things anymore, but they are what they are animal sentient beings, the interpretation has to change as well. So, exemplary given, the freedom to express natural behavior in reference to a legal person who is not someone's ownership would not be able anymore, as it is now, to be understood as giving maybe enough space that animals do not get traumatized enough to show signs of self-injury, but it would have to be seen as a possibility to spend one's life in conditions similar to a natural habitat of a certain individual. In case of cows or pigs, this would be, in my understanding, spending lives on the green grass, enjoying natural sunlight, socializing with the mates. And what is also very important, not being deprived of bonding with their children. This is just something opposite to the lives of farmed animals today, even though the 5 freedoms are claimed to be the foundations of today's animal welfare laws in the EU. However, the problem is the interpretation. If animals are owned and they are still something similar to things. These 5 freedoms are being interpreted in a very, very narrow scope. This development of 5 freedoms has, however, led to the emergence of the concept of the life worth living with regard to animals. Which we call the life worth living, and it has to be distinguished from the 5 freedoms model by placing greater emphasis on the balance between negative and positive experiences of animals. So the mental states that have been identified as positive emotional responses in the 5 domains model of David Mellor constitute the alternative to 5 freedoms model, and these are, for example, joy, comfort, and curiosity. This enables the animal to live in a life that is, in its optimal state, a good life. So, for example, animals shall not only be free of hunger, but enjoy pleasure of access to nutritious food. This is what I propose, that it is a scope of rights that shall be protected by human guardians. In each case, this would be persons responsible to take care for an animal. In case of privately owned animals, this would be those who are today animals owners. In case of wild animals, this would be the state itself. In case of farm animals, this would be the owners of the farms, who, even if do not have enough compassion towards their animals, they will have to ensure that the basic freedoms or rights of animals they keep will be protected by them and obeyed by their employees. Of course, there might be misusages, just as we encountered today between the guardians and their wards. Even today, we hear about raping or torturing children by their guardians. And for this reason, there shall be special institutions that will be liable to ensure that these assumptions are secured. This is not that difficult, whether the police will undergo an obligatory training regarding animal rights or a special state body would react in case if there would be any doubts regarding granting these basic rights to animals. This is what I believe is a secondary issue. But the ideal state would obviously be ending animal slaughter and allowing for existence of solely animal-friendly farming, which can be observed today in animal sanctuaries or animal farms, like in United Kingdom, the Ahimsa milk farm that was mentioned by Sean and Raphael to me before, or other farms operating on the basis of non-violent coexistence. However, allowing animals to live their lives full of positive experiences without separating calves from mothers, and allowing animals to express their natural behavior, living outside before they die, is something what I believe that we can already achieve in the very soon future. This is also what we should treat as a step-by-step approach. And this can be achieved already by interpreting the existing laws to the new legal reality, which would be replacing the ownership with the guardianship. So summing up, because I see the time is ticking, I believe that currently there are no absolutely wrong rights for animals. They are just wrongly interpreted because of the foundations, how the position of animals is structured. So the wrong interpretations come from the subject to which they refer. Currently, animals are, in the broadest possible interpretation, quasi-property. Once animals become a different category of animals, and are no longer owned, but instead cared for and respected by humans acting in their interest as their guardians, the interpretation of any rights given to them will automatically change. Therefore, applying the 5 freedoms model in the modification introduced by David Mellor through the 5 domains model, and also in the understanding of the Martha Nussbaum's idea of the freedom to express natural behavior in terms of the right to flourish, which may be interpreted differently in reference to every species, will be possible through changing the category to which animals are assigned. So the right to express natural behavior in the case of property or quasi-property must be interpreted differently to the right of a living animal that does not constitute property, but rather one's word. I believe that first, humans have to understand why it is important to care for animals to have a good life. And first, then we can make everyone understand, the other people understand, that it is important not to kill them. And this way, we can achieve higher standards of animal rights with time by using the step-by-step approach and still aiming at the highest possible level of granting animal rights with this, what we already have in our European legal framework. Thank you very much.